start. So hello, my name is Dr. Claire James. I'm a lecturer in law in the University of Leeds. My research considers the potential of the right to food to shape food and agricultural policy. My research also considers aspects of the implementation of socio-economic human rights and their justiciability. I also have interests in animal welfare and the law. It is my pleasure to welcome you to this virtual seminar of the Global Food and Environment Institute, Good Samaritan Laws and Surplus Food, a solution in need of a problem, which will be presented by Dr Carrie Bradshaw, Associate Professor in Law at the University of Leeds. Dr Bradshaw examines food waste as a distinct legal and policy problem. She has been an ESRC Parliamentary Academic Fellow, seconded to the Parliamentary Office of Science and Technology, and commissioned to write a major report on food waste. By demonstrating the limited evidence base for non-legislative interventions, the report provided an underpinning case for new legislation to prevent food waste. Carrie has also provided oral and written evidence to Parliament and advised several government, business and third sector organisations on food waste, law and policy. She has a general research background in environmental law and retains research interests in tort, particularly the relationship between tortious liability and corporate responsibility. Also joining us is Ali Gorney, who is Public Affairs, Policy and Campaigns Consultant for FareShare. FareShare is the UK's leading food distributing charity, harnessing the power of food to change lives. Ali leads on government relations, ensuring the environmental impact and social value of food are on the political agenda. He has recently led FareShare and the Felix Project's successful 4-year campaign to secure 15 million to redistribute surplus food directly from farms to charities. With a background in political communications and campaigns, Ali has worked in the West Country, Westminster and Brussels, where he served as head of communications for a European Parliament delegation. Always passionate about food, Ali worked as a chef before entering the world of politics and policy. So Ali will be running the Q&A session after Carrie's presentation, so please add any questions for him and Carrie in the chat. The Global Food and Environment Institute is an interdisciplinary research community which brings together members from across academia, industry and public policy to work on the integrated challenges of food security and climate change. There are links in the chat. And this seminar is part of a series of seminars, so please check the chat function with a link to our series advertised on Eventbrite. Before I welcome Dr. Carrie Bradshaw, I would like to remind you of the seminar etiquette. Please ensure that your cameras and microphones are switched off for the duration of the seminar. The presentation will take about 20 minutes, during which please use the chat function, address to everyone with your questions. At the end of the presentation, there will be a Q&A session where Ali will collate questions from the chat function. May I remind you that the seminar is being recorded and a recording will be made available via YouTube. So now I would like to welcome Dr. Carrie Bradshaw.
Thanks, Claire. Thanks, Ali. Thank you everyone for being here today. Edible surplus food is produced at every stage of the food supply chain. Redistributing this surplus for people to eat, often people who are food insecure, has the potential to prevent food waste. A widely reported barrier to donating surplus food and redistributing it, however, is reportedly a fear of liability should recipients become ill after consuming donated food. And this fear of liability is said to deter or prevent businesses and charities from donating surplus food. In response, many researchers, institutions and politicians have recommended changes to liability rules, sometimes known as Good Samaritan laws. Good Samaritan laws come in various forms. Broadly, they provide differing levels of protection from criminal and/or civil liability for donating surplus food. And often, but not always, they remove what's called strict liability. So strict liability is liability without fault, so that a donor who's strictly liable may have taken all reasonable measures to prevent that harm and could still be held legally liable. I think my slides are moving automatically on their own. I don't know why. I apologise for that. Notable examples of countries that have such laws to encourage donating surplus food include the USA, which has had federal Good Samaritan law in place for food donations since 1996. And Singapore also recently passed a food donation Good Samaritan law in 2024. My talk today will outline initial research findings from an ongoing project that ultimately questions whether these laws are necessary or desirable. In the first part of the talk, I'll go through the empirical case for these laws and outline my ongoing review of the evidence of the underlying fear of liability claims. And in the second part, I'll consider the legal case for Good Samaritan laws as a solution potentially to what I think are two different but not unrelated liability concerns. So, starting with that first question, what do we actually know about the fear of liability and food donation? So as I said, my review of the evidence here is ongoing, and I'm still in the process of undertaking what's called a scoping review. But the tentative conclusion I want to offer today is that this claim about liability fears is neither well grounded empirically in the literature nor well articulated. So my starting point, before I even designed a scoping review, was to look at existing systematic and other evidence reviews on the causes of food waste and barriers to surplus food donation, and in particular, to look at what evidence those reviews were citing when they were making a finding that a fear of liability was a problem in the context of food donation. And the first two evidence reviews that I looked at made this claim about liability fears and then offered little or no robust evidence to support their finding that a liability fear was either widespread or a well-founded concern. So the literature cited in support of these findings either were literature that didn't even make a claim about a fear of liability or relied merely on anecdote to make a widespread claim about fear of liability across the supply chain. There were some systematic reviews and ones that focused mostly on primary academic research, which did identify some studies which in turn provide evidence of liability fears amongst relevant actors. But so far I haven't found many of those studies. And from the ones that I have looked at, we still don't know a lot about the true nature, prevalence, degree, and source of reported liability concerns. So, for example, the existing research provides only limited insight into whether the fears are about liability rather than, say, reputation, whether these fears are widely held or not, and by whom. Is it retailers, restaurants, redistribution charities that are worried, large or small organisations? Whether liability fears are more determinative than other constraints, such as economic or logistical barriers to donation. And importantly, there's often a lack of clarity as to what the actual source of the legal fear is. Is it civil tortious liability? Is it criminal liability? Is it regulatory non-compliance that underlies these reported fears? And that latter point is really important. That source of liability is really important to know, because some studies cite legal obligations as a barrier to food donation, which Good Samaritan laws don't address. So legal problems that this so-called solution just doesn't touch. Now, of course, a lack of evidence for a fear of liability doesn't mean there isn't a fear of liability. It's just that the evidence is lacking. And there may well indeed be liability fears. And as I argue later, it's not necessarily a bad thing that liability is a concern. But we need to better understand the nature of the fears before adopting legislative interventions which change the law. And to be clear, passing legislation to disapply the general principles of civil, criminal, and/or regulatory law and the protections they provide is a potentially drastic measure. I don't know why the slides are moving automatically, I apologise. So in that regard, another limitation of the existing evidence and my review of it so far is that it fails to articulate and distinguish between what are actually two separate liability problems with potentially different solutions. So the first problem is basically one of over-deterrence. So some people argue that liability is too strict, too stringent, or too expansive. And what this really means, impliedly, if not explicitly, is that liability is too strict relative to the aim of preventing food waste and feeding food to people. And so far, most, although not all, of the studies that I've identified that make this claim about strictness fail to acknowledge the inevitable value judgment involved in striking a balance between food waste prevention and food safety. And I'm nervous in particular about those studies which draw a conclusion that the law is too strict without acknowledging that the law here, as I'll come back to, can serve a broader positive social purpose, including ensuring food safety and or allowing people to receive compensation for harm caused by food. The second liability problem is a knowledge-related problem, either that there's a lack of knowledge or certainty about the law, or there's confusion about what the law actually says, and that this is what deters or prevents food donation. So not the law is too strict, but rather I don't know or understand what the law says. Now, there are some peer-reviewed academic studies to support empirically that there is a lack of knowledge, but again, it's unclear how prevalent this is, particularly across different sectors. Are large retailers with their own in-house legal advice really that worried about it compared with small charities? And again, we don't know really how this evidence operates in specific jurisdictions. At the same time, the thing that I want to sort of emphasize here when we think about the evidence is that there's lots of reports and studies that take a lack of knowledge as kind of a given, as background or context, without any or sometimes only limited evidence to support the claim, and often without any specificity. So again, what is it about the law that people don't understand or find confusing, and which specific laws? There are some studies which demonstrate uncertainty and confusion amongst people who participated in the study, but also remark that these findings were surprising or unexpected. So there was a German study that found this and said, we don't understand why this is the case. The legal situation here is pretty clear. Finally, and it's worth keeping this in mind as to whether you want to recommend a Good Samaritan law, misperceptions about the likelihood of liability can persist even in the presence of a Good Samaritan law. So there was one US study that identified widespread fears amongst respondent restaurants, even though there's been liability protections in place in the US since 1996. And the authors said that these fears were unfounded in view of that. So these two liability problems are not really identified or demarcated properly in the literature, including in the literature calling for Good Samaritan laws. This is problematic because they could obviously imply different solutions. So if the law is too strict, we might want to change it. But if people don't understand what the law is, maybe they need help to do so. And for me as a lawyer, these two problems raise related legal questions that in turn I think are helpful in unpacking a broader case against potential Good Samaritan laws. And so these two questions flow from those findings in the literature. The first one is the law too strict? Are concerns about over-deterrence justified in view of what the law in that particular jurisdiction actually says? And secondly, does potential confusion or uncertainty arise from the law itself? Is the law itself confusing or uncertain? So taking the first question, is the law too strict? Now, obviously, this depends on the jurisdiction, but using England as an example, I think the answer to this question is probably no. I'm conscious that I think we have a couple of lawyers in the audience here, but most aren't. So I'm going to skim over some of that detail. But as you'll see from the brief examples that I give, the main reason that I think the law is not too strict is because we already have existing protections in England that I think mean GS laws, Good Samaritan laws, may be unnecessary. So England, like most jurisdictions, has various criminal offences for selling and donating food that's unsafe and for not complying with various food hygiene requirements. The penalties for these offences is quite severe, so potentially an unlimited fine and or 2 years imprisonment. And these strict liability, sometimes called regulatory offences, are routine and commonplace in the context of consumer protection and public health. But in England, and most of the UK's devolved nations, actually all of the UK's devolved nations, these strict liability regulatory offences come with due diligence defences. So basically, if a food donor or anyone handling food can demonstrate that they took all reasonable precautions and exercised all due diligence, basically that they were careful, followed guidance, took active measures to train and supervise their staff, all the types of things that you want people handling food to do, if they can show that, they won't be guilty of an offence. And it's really important to note that providing a record of that system is something that's expected under food hygiene requirements. And if you've done that, this isn't even going to get into a courtroom. So enforcement officers understand very well what constitutes a good due diligence system, and don't prosecute where that system exists. So in this sense, that due diligence offence is less about very unlikely legal proceedings if you've done what you're supposed to, and more an integral and essential part of good food practice. And it's probably worth mentioning that a due diligence or no negligence defence is very similar to what Singapore has already done. But as I've already said, as you've already heard, we have that already built into our general food law here in the UK. England and the UK also has tort laws which, like other jurisdictions, require compensation to be paid for harm caused by negligently supplied or defective food. But as with the criminal law, some protection already exists. So, for example, in claims for negligence, to be found liable, a claimant would have to prove that the organisation or the individual failed to take reasonable care. So they didn't do the things that a reasonable person would be expected to do when handling and donating food. The courts already consider the social benefit of an activity when determining whether to impose liability, and in particular whether liability here would prevent that beneficial activity from being undertaken. And we've already had legislative interventions from Parliament in 2006 and again in 2015, confirming that the courts may, and in some circumstances must, do this, take into account the social benefit of an activity. So the fact that food is being donated rather than sold is already part of the equation in our general law as it applies to food. It's also important to note what negligence does here. If we hold someone negligent, we're saying they haven't taken steps considered reasonable in the context of donating food, and we're holding them, or more likely their insurers, liable for harm which that has caused. Under the US Good Samaritan law, there'd be no liability here. There's only liability if there was gross negligence or intentional misconduct. And I think people in their enthusiasm for Good Samaritan laws, like the US example, often forget that in doing so, they're essentially condoning negligence, condoning a lack of care, simply because food is being donated rather than sold. Lots of the concern about the UK law seems to be about a different type of compensation claim, strict liability for harm caused by defective products, or in this case, defective food. I'm not going to get into too much detail about that today. Needless to say, several defences already apply, including 2 in respect of non-profit activities. So there's some protection there. Now, these protections across tort and criminal law may be imperfect. However, all of the claims in the literature that I've identified so far that the law in England is too strict, all of these claims fail to acknowledge these existing protections. And the only publicly available legal guide to food donation in the UK fails to mention or evaluate these, but nonetheless calls for a Good Samaritan law all the same. So without considering these existing protections, these claims that the law is too strict in England are just simply not credible. And so in England, given the law is not as strict as seems to be commonly assumed, I think Good Samaritan laws are potentially unnecessary. Moving to the second question, is the law confusing or uncertain? I think the answer to this is probably yes, actually. Although I'm not sure this is particularly surprising or unique in this area of law compared to other areas of law. There's a reason why we need lawyers, although some might argue that lawyers are very good at creating the need for lawyers. But I think the answer here is yes. This confusion won't have been helped by the fact that that UK legal guide that I mentioned contains significant errors and omissions. I think there's a big case for correcting that. And based on my analysis of the legal principles of how these general rules of law apply to the context of donated food, I think my research suggests that there is some confusion and uncertainty within the law itself. So a good example of this is whether retailers are strictly liable for any harm caused by selling or donating their own brand produce. The UK's leading practitioners and textbooks argue that retailers aren't liable. I think those lawyers are wrong. I think retailers are strictly liable for their own brand produce. But that's just one example of the definite scope for disagreement in how these rules apply. And it's also possible that the existing protections I have mentioned provide less certainty to actors than a Good Samaritan law defence would. But before jumping to implement a Good Samaritan law to provide that certainty, to provide a scope of no liability or immunity or judgment proofing, I think we should remember that even when they have these protections in some countries, the people or organisations they're designed to protect don't necessarily know about them. So I've already alluded to evidence of that in the US. We have some evidence of that in the UK too, albeit in a different context. I'm sorry, my slides keep moving. The UK, where have we got to? Yes. So some evidence of uncertainty of a lack of knowledge about existing protections in the UK. In addition, removing or significantly restricting liability to solve a problem of uncertainty or confusion or a lack of knowledge seems heavy-handed. And this is particularly the case because criminal and tort laws governing food, as I've already alluded to, can serve a protective social purpose. So restricting liability could have negative side effects for food safety and leave recipients of surplus food, many of whom are already somewhat disempowered or food insecure. It can leave those people open to harm. On the other hand, there's also no guarantee that these Good Samaritan laws actually prevent waste. So there's a US study that found that liability protection in the USA correlated with increased levels of food donation, but higher levels of food waste as well. There's also a large body of academic and other opinion arguing that donating or redistributing surplus food on a large scale should be a time-limited intervention because it's not a proper solution to the problems of having too much food, too much waste, and too much inequality. And arguably, Good Samaritan laws are a legal institutionalization of that potential sort of lose-lose future scenario of high levels of surplus, high levels of waste, and high levels of inequality. Even if we are minded to provide some protection here, I think there's a case for restricting that protection just to charitable redistribution organisations. So this is what Italy's Good Samaritan food donation law does. I haven't said this publicly before, but I'm going to say it now. Retailers and supermarkets donating large quantities of food, which they have deliberately over-ordered and priced in as part of their business model, those retailers are not Good Samaritans. For similar reasons, I'm really concerned about the recently expanded scope of the US liability protections. So they've been in place since 1996, but in 2023, they are amended so they apply not just in the context of food donation, but also apply to food that has been sold for a, and I quote, Good Samaritan law reduced price. So this price is basically allowing liability protections, not just for donated food, but for food that's sold at a reduced price that reflects the costs of redistributing that donated food. So for these reasons, I think communicating through better guidance what the rules actually are, including pre-existing legal protections, seems a more appropriate and proportionate intervention than changing the law. But ultimately, though, and I hope my scoping review when it's finished will help with this, we do need more research to fully understand the true nature, prevalence, degree, and source of liability concerns before deciding what, if anything, to do about it. And that's me finished. Thank you very much for listening, and I'm sorry that the slides kept moving without my intervention.
Thank you so much, Carrie. That was absolutely brilliant. It's really unique work that you're doing and very, very valuable for everyone who works in the food redistribution space and wider food policy space. As Claire said at the start, my name's Ali. I lead on public affairs and policy for FareShare, with the UK's largest food redistribution charity, taking surplus food that would go to waste from the food industry and redistributing to about 8,000 charities. So we're kind of like a wholesaler for the charitable food sector. Um, we pulled together a manifesto that's looking at uh, all of the different policy levers that the government could pull to reduce waste and encourage surplus donation. And in fact, it was Carrie's counsel that meant that we didn't go in all guns blazing with a request for a Good Samaritan law, and held our horses a bit and are now calling for clarification around legal protections for Good Samaritans. So we've changed our government ask, and so in conversations that we are currently having with DEFRA and various other government bodies, we're highlighting the importance of clarity of already existing laws. And, we look forward to working together on really hammering out what the evidence base needs to be before any work continues or before anything goes public. So yeah, no, it's really, really valuable work. If anyone's got any questions, please put them in the chat. I've just seen one come in right now. It's about India. India doesn't have a law like a Good Samaritan law around surplus redistribution. How can someone who's not a lawyer get involved in working towards sort of clarifications around guidance in India? And we can probably widen that to other countries.
Yeah, great. Thank you, Ali, and great question, Arena. I mean, I think the main thing that I would say is the fact that India doesn't have a Good Samaritan law, and I don't believe it has. I'm not aware of it, but maybe it does. Is a good thing, probably. I'm not sure Good Samaritan laws, as I've said, are always necessary or desirable. I think if you're interested in the not unreasonable aim of trying to make sure that surplus is eaten rather than wasted, I have no problem with that. Then encouraging people to understand what the actual legal rules that apply are is probably really important. And also developing an evidence base about what the real barriers are to food donation. And as I said, I mean, my evidence review will pick up, I suspect, maybe a couple of studies in India. I haven't come across any yet. I've found one in Pakistan. But as I said, it might be a welcome thing that these laws don't exist, and guidance may be more important. And even with guidance, I'm hesitant. I think we do need guidance. I certainly think you need to correct anything in the public space that's not correct. But we do need to move away from societies built on the kind of paradoxical coexistence of high levels of surplus food, high levels of waste, and high levels of inequality and so-called food poverty.
Excellent. Thank you. So the next question is around who are the people who are calling for such laws? Is it redistribution apps or charities? Is it larger supermarkets? Or is it everyone involved in redistribution?
Yeah, I mean, Ali, I guess you might know the answer to that as well. I mean, obviously, FareShare no longer call for such laws, they call for guidance instead. The examples that I've seen in print, and that obviously may not represent what happens behind the scenes and with lobbying, but the examples I've seen are some pretty big organizations around food waste. So WWF and RAP. So RAP is the main organisation in the UK that governs our approach to food waste prevention. WWF and RAP produced a report in 2020 that suggested changes to liability laws could be a good measure to increase donation and food waste prevention. A very prestigious and influential report by the Harvard Food Law Clinic has recommended that the UK should adopt a Good Samaritan law. And we've had politicians in the UK who I think maybe have changed their mind more recently, but have proposed their own private members' bills for Good Samaritan laws in the UK. I suspect the private sector is probably more sanguine about this. I don't have evidence for this, but my suspicion is they have their own in-house legal advice, and so they know what the law is. And certainly the big retailers will be able to know, what is arguable or not. And I hope that answers your question, Claire.
If I can add to that,
Yeah,
I think people in the space, whether it be charities or politicians, are looking for quick fixes that would enable more food getting out to people. I think, and that's really, really tempting because ultimately the sector has the problem that you have enormous amounts of demand and not enough supply to get food to them, despite there being enormous amounts of waste. So logically speaking, it's very easy to get to a point where you think a Good Samaritan law is the thing that solves that, and it's quite politically appealing because it's like just a really easy thing to get through Parliament and then job done. Like I can, as a political campaigner, I can see the value in that. The fact is that the reality is different, and so I think the sector needs to work together, and I think it's probably on organisations like FareShare to work with both charitable sector colleagues and private sector colleagues like Olio or Too Good to Go to sort of hammer out the evidence base and figure out where we want to go here.
yeah.
We've got another question around supermarkets. So can you explain, Carrie, what supermarkets are doing when they deliberately over-order, which results in them not being able to, not being Good Samaritans when they give food away? Yeah, could you expand on that point?
I don't I think I'm just going to go straight to the chat because I don't quite understand the question. So, this is Judith's question. Can you explain what supermarkets are doing when they deliberately overorder, resulting in them being not being Good Samaritans when they give this away? Yeah, it's a great question, Judith. So, there's a concept called on-shelf availability, which is the idea that supermarkets are worried about losing out to their competitors if you walk into a shop and the shelves are empty, particularly fresh food and certain other produce. And so the retail sector is very, very competitive. And so this push for on-shelf availability means that they kind of deliberately overorder to avoid the lost opportunity costs of you coming to the store, not being able to get what you want and never coming back again. And that's combined with a supermarket business model that is actually based on really profits held up by selling tobacco and alcohol at a high margin, and selling lots and lots, or ordering lots and lots of things like fresh produce and selling them sometimes at a loss. So, for example, carrots, supermarkets make no profit on carrots, and so they're easily wasteful. So this is a business model that is generative of overproduction and food waste. And supermarkets know this and they price in the cost of throwing stuff away. So when they donate it, I think it's a stretch to call them Good Samaritans. Increasingly, because food donation is a way in which retailers are dealing with their waste. And in particular, if they can donate it, they don't have to pay for the food to be anaerobically digested or landfilled. So that's why I think they're not Good Samaritans. I hope that answers the question, Judith.
Brilliant, thank you. So there are trading standard regulations on breaking up and relabeling catering packs, and having no ingredient allergen lists on loose bakery products, that restrict lots of the projects that the person who's asking question works with. How do these regulations fit into the concerns around laws being too strict or confusing?
Yeah, Millie, so this is a really good question, and it's why the evidence is really important. So these are examples of kind of concerns about regulatory non-compliance. Yes, I think they're extensive. I think some of them are probably confusing. But every single Good Samaritan law that I've seen would leave those regulatory obligations intact. It wouldn't touch them. So the point I sort of make in that regard is that the Good Samaritan laws are sometimes posited as a solution to a problem that they wouldn't address at all. So I hope that answers the question, Millie.
Brilliant, thank you. And Charlotte is asking if Good Samaritan laws are the wrong answer to the wrong problem, how would you categorize the real problem and even the right answers?
I think if that's Charlotte O'Brien from the University of York, it's lovely to have you in the room, Charlotte. Great question. If GSL laws are the wrong answer to the wrong problem, how do you characterize the real problem? The real problem, Charlotte, is a broken food system, and a society that is characterized by increasing levels of food insecurity. The right answer to that are not liability protections. That's a sticking plaster, and potentially a sticking plaster on the wrong wound. I think the right answer is in a fairer food system. And I'm afraid, Charlotte, that's a whole other paper, and lots of people have written about that. But that if we're going to pile legislative energy, then it needs to be in measures that would make our food system fairer for the people who work in it and the people who rely on it.
Thank you. That's the end of the questions in the chat as stands. Does anyone have any other questions? Don't see anyone typing. Carrie, is there anything? Oh, we've got one more here. What about the risks of processed foods? Andrew is asking.
What about the risks of processed foods? Andrew, I'd love if you wanted to expand on that. I mean, do you mean the health risks of processed foods? Yeah, they're really big ones. I don't know if you're thinking whether maybe there could be litigation around that. I don't know is the answer. So potentially, maybe you could see a litigation in the spirit of, tobacco and climate change. But I'm not sure if that's what you're getting at, Andrew.
Andrew has come back saying, talking about health and nutritional value lacking.
Yeah, I mean, this is a real problem that, we produce too much of certain types of food and don't consume enough of other healthier ones. I think, this is a sort of similar answer to what I was saying to Charlotte, that we have, a food system that at a basic level supplies a lot of people, but not everyone, with a range of food to eat. It's not a food system that is environmentally and socially sustainable in the long term. And part of that picture is that we have too much surplus, too much waste, but it's also that we are probably not producing and consuming the right things. And yeah, that needs sort of widespread, deep, fundamental changes to our food system. That I think, Andrew, a Good Samaritan law is going to do very little to address.
I'm just going back through the chat and I see some points that I've questioned I've missed. Hermione is asking, what would be the major obstacle for laws in preventing food to be redistributed through donation and or redistribution?
What are the laws that are an obstacle to food redistribution?
Yeah, I guess it's I don't know if there are any laws that are obstacles in of themselves, or what are
Yeah.
what could be introduced that isn't being, or do you think there are laws that exist that are obstacles?
Yeah. I mean, so the laws that are potential barriers to redistribution are the ones that I've kind of already highlighted. But I wouldn't phrase them as barriers necessarily, because they serve a purpose. We have criminal offences in this place for a reason. We have negligence liability in this place for a reason. I think the barriers to making those work properly are probably not in the law themselves, but in the fact that, the general leniency towards volunteers and food donors that already exists in the law is not widely appreciated by the people who are, doing the day-to-day work of food redistribution. So I think we've got a big communications challenge, and that's not necessarily a kind of a new observation. I think it would be relatively uncontroversial to say that. But there's always a difficulty in providing legal advice, so Ali and I are really keen to have some guidance about the existing protections, but these situations will always be somewhat fact or context specific. So until an actual factual matrix exists, we can't always say what the legal outcome would be. What I would say, and I didn't say this in the talk, is that the likelihood, particularly of tortious liability, of having to pay compensation for harm caused by donated food, is infinitesimal for all sorts of reasons, mostly because proving causation in most cases would be almost impossible. So until we're able to communicate that really small chance of liability, I don't think any of these laws are going to be helpful.
That's a really good answer. I'm also going to shamelessly plug our manifesto in the chat that
Yeah, go for it.
looks well, it's an articulation of what we think the current barriers are to redistribution, or what the government could introduce that would mean that more surplus food comes to the redistribution sector. Obviously, we don't want to prioritize redistributing more surplus, so and thus doing so incentivize waste. We want to prevent waste at the start, and there are also complex questions around how does this fit in what we want to do in terms of societal reforms. And obviously we don't want a country where we are reliant on food aid, but we want people to engage with the charity sector when they're choosing to do so. So this is a very sort of niche part of a much wider policy space. But if we nail some of this stuff, then I think there's actually a huge appetite to change around this and introduce progressive policy around this with noises the government making around zero waste economy, circular economy, and bringing charities and the community sector into the heart of government. So I think there are legs on this work, and it's really important that you're doing it. So thank you. I think that we're just about out of time. So I'm gonna wrap up, but I'm sure if anyone's got any other questions for Carrie, they can get in touch with contact details on the slide. And of course, if you have questions for me, please do get in touch. Carrie, thank you so much.
Likewise, Ali, and thank you everyone for coming.
Bye.